You are on bond for an assault in this case, and you've now picked up a new case.
Welcome back to another explosive courtroom breakdown. And let me tell you, today's session is absolutely packed with drama. We got a defendant who made 21 phone calls in a single day to someone he was ordered not to contact, and the judge is not having it. But that's just the appetizer. We got a Dick's Sporting Goods theft case where someone was covering for a shoplifter and got physical with an off-duty officer. And you will not believe how the judge rules on probable cause. Then there's an aggravated assault where someone beat their ex with a metal bracket over a broken phone, causing lacerations to both eyes. And if that wasn't enough, we got a 23-year-old wanted in Indiana for fraud, forgery, and identity deception who's been picking up 1 to 2 criminal cases every year since becoming an adult. The judge calls him a Tasmanian devil, leaving a path of destruction. Bond revocation, fugitive cases, extradition drama. This one has everything. Let's dive in.
What happened to the violation of protective order, please?
Yes, Your Honor. On March 18th, 2025, Harris County, Texas, the officer met with claimants for a BPO call from service. The officer met with claimants when he filed with the defense center learning text messages and called her 21 times. Claimant said calls for 1 day after the 61-day protective order expired. The defendant has a no contact order in place out of 45.
You don't get it. You don't get it. I only have one thing to do. I'm sorry, I'm revoking your bond, putting you in jail. I ordered you not to do something and you're doing whatever you want to do. Doesn't work like that. There are serious consequences. Goes with you.
Stop right there. Did you catch that number? 21 phone calls in a single day to someone he was court-ordered not to contact. Let that sink in. This defendant was already on bond for an assault case, meaning he was given the privilege of freedom while awaiting trial. And what does he do? He violated a protective order by bombarding the victim with 21 calls in 24 hours. The judge's reaction says it all. You don't get it. You don't get it. This is what happens when defendants treat bond conditions like suggestions instead of requirements. And notice the immediate consequence. Bond revoked, going to jail, and the judge is now setting the assault bond at $50,000. Plus, a new protective order is being put in place. And if he violates that one, the judge is promising a hearing to hold him at NO bond. That means sitting in jail until trial with absolutely no option to get out. This is a legal system saying, we warned you and you didn't listen. When you're on bond, every action is being watched. Every violation has consequences. What do you think? Was revoking bond the right call here?
This is Montes.
Did you want another motion?
Yeah.
Okay.
Yeah. Oh, I'm putting a new MOA on him, and I'm going to advise him that if he violates it again, we'll have a hearing to hold him at no bond. Okay? Because the second one, I can have a hearing. I will only touch the assault case, and I'm going to put it at 5,001. He is made bond on the VPO.
He was given a PR.
They gave him a PR bond on the VPO. It's like, I don't know if I'm going to keep the PR bond on the VPO as well. Just.
Well, Judge, there were multiple orders in this case for bond conditions, and the one that ordered no contact was not labeled an order in the computer, so I didn't see it. There was another one that was no threatening or harassing, and a third one, and that was blank, and all it said was all conditions to be supervised by the department.
That means they're following the conditions in the state's motion filed on that same day.
Say it again.
Oh.
That
okay.
order will mean that they're supposed to be following the conditions in the state's motion that are filed on the same day as that transporter.
Tell him ad nauseum, you know. I'll leave the VPO as is, okay?
Yeah.
I'm putting a new protective order in today, and I'll advise him that he's not to have contact with this person. And if he does again, I'll have a hearing to hold him at no bond. Okay? So yeah, the VPO, he's made bond 2,500, and at the assault, I'm putting it at 5,001. Okay? Good morning, Mr. Jordan. So you're charged with interference in the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On March 27, 2025, an officer was working a second job at Dick's Sporting Goods in Harris County, Texas, and was approached by the store manager, the witness. This advised the officer that the defendant walked into the store with another individual, and the witness advised the officer the other individual with the defendant walked out of the store without paying for any merchandise. The complaining witness stated he wanted the defendant to trespass because the defendant was seen on camera attempting to cover the individual while the individual was stealing merchandise. The officer stopped the defendant at the front entrance of the store, and the officer stated the defendant would be trespassing the store. The defendant became irate and more aggressive. The officer ordered the defendant to place his hands behind his back and place handcuffs on the defendant's right wrist. The defendant twisted his body and tensed his muscles. The defendant, with a great amount of force, threw his left arm forward and threw his left arm backwards towards the officer. The officer attempted to gain control of the defendant's left arm. The defendant began pulling away, and the officer to grab the defendant's body with both arms and guide the defendant toward a rack where the officer was able to excuse me, Your Honor, tongue twister, where they were able to detain the defendant. The defendant was identified by his Texas driver's license.
What's he under arrest for?
I believe he was under arrest for trespass originally, Your Honor.
Oh.
You Yes, Your Honor. We just have a brief moment.
Are you losing? Are you losing?
Your Honor, the only thing I have is that the suspect began acting irate and clearly becoming more aggressive, and then the officer went to detain the suspect by grabbing his right wrist.
No. All right. When you get into a pissing match with the people who have the power of arrest, who's going to win every single time? You know what I mean? Every single time. Sometimes it's better to tuck your tail at times because you may end up winning in the long run. I'm going to find no probable cause in the case. Just be careful, man. I probably wouldn't go back to the sticks because it's not going to go well. You know what I mean? All right, hang tight.
Now, this is a moment that caught me completely off guard, and is a perfect example of why probable cause hearings matter. Let's break down what happened. The defendant walks into Dick's Sporting Goods with someone else. That other person steals merchandise and walks out. The defendant is accused of covering for the thief on camera. He gets stopped, becomes irate, physically resists when the officer tries to cuff him, throwing his arm forward and backward, twisting, tensing muscles. Sounds like a clear-cut interference case, right? But here's where it gets interesting. The judge asked a critical question. What was he under arrest for? The answer was trespass. But here's the thing. Becoming irate and aggressive by itself isn't necessarily a crime. The judge found no probable cause to proceed. And then he dropped some real wisdom. When you get into a pissing match with people who have the power of arrest, who's going to win? Every single time. Even when you win the legal battle, you can still lose the physical encounter. The judge's advice? Sometimes it's better to tuck your tail. And I probably wouldn't go back to that Dick's. It's not going to go well. This is a rare win for a defendant in probable cause court. But the lesson remains. Don't escalate situations with officers, even if you think you're right.
I am here on Destiny Drake Osby. Yesterday, you ordered that she appear today. I was appointed last Friday. She caught a new ag assault family member in another court.
Now,
She is in court 8's holdover right now.
do you mind bringing up please?
Last name is Drake-Osby. The case before you, like I said, it was recently appointed a week ago today. It looks like the arrest was the following day or whatever this new thing is.
This is for the.
Well, no, the new law violation that she caught in felony
Let's
court.
hold on before because I want her to hear.
Gotcha.
I'm in shock. On bond for DWI with us, and you've now picked up an aggravated assault of a family member. You might dismiss Drake Osby. What happened in the ag assault, please?
Yes, Your Honor. On April 1st, 2020, as first specified, the plaintiff and the defendant are exes from a prior dating relationship. On April 1st, 2025, an officer was dispatched to an address in Harris County, Texas, responsible for service call. The complainant stated there was a verbal altercation when the defendant took the complainant's cell phone. The defendant then entered the bedroom and began striking phone and objects to break it. The complainant was able to retrieve his cell phone, at which time the defendant began to strike the complainant in the head and torso with a closed fist, causing him to fall on the ground. The complainant was able to walk away, and the defendant grabbed a metal object and struck the complainant in the head and arm, causing 2 lacerations on his left eye and a laceration on his right eye, and multiple scratches on both arms. The defendant then jumped the fence and fled the scene. The object was a solid metal bracket, 12 to 16 inches in width, made of heavy gauge steel designed to hold 2 cylindrical metal tubes and has multiple sharp triggers. The item is manufactured for law enforcement officer use as a mounting or deployment device for tire deflation.
Okay, we need to fully process what we just heard because this case is brutal. Let me walk you through the escalation. It starts as a verbal altercation over a cell phone. The defendant takes a victim's phone, goes into the bedroom, and starts striking it to break it. When the victim retrieved their phone, the defendant begins hitting them in the head and torso with closed fists, hard enough to knock them to the ground. But it doesn't stop there. The defendant then grabs a metal bracket, described as 12 to 16 inches wide, made of heavy metal tubes, and strikes the victim in the head and arm. The result? 2 lacerations on the left eye, a laceration on the right eye, multiple scratches on both arms. All of this over a phone. And here's the context that makes it even worse. This defendant was already on bond for DWI in this court. She was given the privilege of pre-trial release, and within a week of getting a new lawyer appointed, she picks up an aggravated assault on a family member, which is a felony. The judge's response? Bond revoked on the DWI case. New bond set at $51,000. She hasn't made bond on the felony yet either. This is what happens when you take freedom for granted and let anger control your actions.
And all this over a phone? Mr. Drake Osby, I now have to revoke your bond in our case as well. I'm sorry, so I'm going to set it at 5,001. You've still not made bond on the felony case, so if you do, I mean, we can talk, but John, I think he's set for when? She's set for
514, Your Honor. Yes, sir.
Okay, do you want to do, I guess, the day after then?
You look at one other thing, Judge.
Well, I think the felony is actually set for Monday. Our case before this one was caught up was when she was reset for 514.
It's up to, I'm good with whatever you want to.
I'm actually looking, I don't have any new discovery to look over because this case is so new. There weren't even any body cams for me, so I'm pretty much waiting on everything. I'll leave it where it is and I'll monitor things and see what's going on with the felony case, Judge.
Okay. All right. Thanks.
Thank you, Judge.
So I've got a couple to talk to you about.
Okay.
Start with the easier one first. Mr. Ally, he,
Marquise Heller?
yes,
Is he in prison?
no, he's on bond. He had a violation because apparently he used random drug tests.
Oh, right. Is he here?
He is here. He went and he's tested. He came back negative, which is positive. But I think there was a miscommunication or a misunderstanding about him having to go drug test. He's got a pretty extensive orange sheet. And he's doing a mental health DTI, which
Remember.
he's done the interview. We're just waiting on the report. So I think it may have just, when he missed the drug test, just a misunderstanding, miscommunication as to what the bond conditions were.
Edward Johnson?
Did you get the report on Ally yet?
I get those emails. I haven't gotten one, but I did speak
I've been
with.
waiting. It's been a long time.
Well, they do them in batches rather than piecemeal. And so we just,
I mean, he went and did it at least 60 days ago, no?
I don't think it's been 60, maybe 30, 45-ish, but he has gone. I did speak with the Harris Center and he,
I remember you told me that he went.
yeah. We're just waiting and the Harris Center, I know that they're very overwhelmed and understaffed and
Right, I get it. What do you want to do?
what, like I said, he's here, his clean, if we
That's
could.
good.
Yes,
Okay, I mean, he's clean, which is great.
Yeah.
Right, so let's set it, I don't know, maybe a week.
okay,
If it's not back in a week, I'm gonna call it. I'll figure it
okay, perfect.
out. Who's
Let's do
next?
that. Mr. Jorge Pena, he's in custody. He has a fugitive case,
Is it what case?
a fugitive case.
Okay, oh, hi,
And,
Amy.
he would like to speak to you about getting a new lawyer.
About a bond?
No, he wants a new court-appointed lawyer. And
Do you mind bringing out Jorge Pena, please? Pena, please.
I don't want to presume to speak for the court,
Is it
but,
upset with you?
okay.
I find that really hard to believe, really.
Judge,
And you go to bat, so I don't get it, right?
this is the first
He
time.
thinks he can get a different result. Is it just because of the fugitive case?
So he has a fugitive case and a local case, which makes it a little more complicated.
He's made bond on the local case, which is good, so the 15 days. Did he waive or did he refuse? Okay. He looks young, huh? Rick, did you find something?
No, Judge, I don't have the website, Judge. You can pass that along, I'll try.
You what?
I don't have the website.
Judge,
Let me just make sure.
the local system says it won't work.
Say it again?
The local system said that it will not work, within 48 hours of them being placed into U.S. custody. I'm not sure if it has been in the last 48 hours that she's been detained by ICE.
You want, hey, it looks like I've got the boyfriend here. Do you want me to get the phone number for this person and I'll give it to you, Rick? You talk to him? Or have you already talked to
I've
him?
been talking to him, Judge. I do have it.
And what's he saying?
He says that he tells me that ICE has her.
That ICE has her.
I don't have any, yes, I don't have verification of it.
Okay, so why don't we do
Apparently-
this? Because state is saying that within 48 hours of them taking, they can't verify it. I guess it takes a bit to hit the system, you know?
Oh, I see, yes.
And
Mhm.
when did they allegedly get her?
Yesterday, it showed that she was out on bond, but she didn't appear yesterday. So apparently,
Judge, if you'd
maybe
like,
a couple of days
contact-
before.
Did it work?
It does give a number for the field office. If you'd like me to reach out and contact them.
Yeah, but you got a lot, I mean, you got a lot of stuff here going on, you know?
County doesn't have a right, Judge?
Yeah, I don't know. I don't know if you you should get that deeply involved, you know what I mean? Because I don't want you to do something that you get in trouble, so. The hold was lifted 3/16. Rick,
Okay, Judge.
so that's been 2 weeks.
Wow. So apparently that's where she's been. I've had no contact with her, Judge.
I mean,
But,
if we can't verify that she's in custody, because I can't, then I'm gonna revoke the bond.
Right, right. I understand.
So I guess,
Maybe-
do you want to see if the guy that's here can provide proof that she's in other than his word?
Right. He tells me that he has a immigration attorney for her. So let me speak to him, Judge. I'll talk to him and then I'll get back with you.
He has like a folder with a bunch of stuff.
Do you have his phone number?
Yes, I do, Judge.
Okay. Do you speak English?
Yeah, I speak English.
Okay, so her lawyer is going to call you now. We need proof that she's actually in immigration custody.
Number and everything, forced it and everything. She has court Monday, doing my immigration, her immigration lawyer, I'll sponsor her and everything.
Okay, so go out there, speak to the lawyer to see what kind of proof that you can bring us and let us know. And
Okay, yeah, I got all the paper you need, the permissions. Okay.
he's going to call you now.
Okay.
Okay,
Will do, Judge. Thanks.
thanks, Rick. Hey, after this. Pena.
Yeah.
Okay, so Mr. Pena, you were wanted out of another state. And I guess your lawyer there are two things. You're not happy with Anna here. And so we need to talk about number one. Number two, a lot of times when people have fugitive cases, they ask for me to set them a bond so they can get out and go turn themselves in. I don't know. I don't know why you're wanted out of the other state. All I know is that you have an open DWI now. And within the last, year and a half, you've picked up 2 other cases with me in this court. So I know you because you keep picking cases up. So I don't care if you have Jesus here. It don't matter who you got, where she's as that good, right? I don't know if I'm going to give you a bond because all I know is you keep picking cases up. And you're only 23. So Amy, tell me about Mr. Payne.
Yes, he's born out of Newton County, Indiana, from business influence, forgery, fraud, and identity deception. This was issued May 14th of 2024. He of course has local cases for DWI, 415. Let me see what else.
What's he wanted for? What was the first part?
Corrupt business influence, forgery, fraud, and then identity deception.
Corrupt business influence, forgery, and fraud. Do we know that they want him?
Yes.
Okay. Is there a bond that's been set there?
I don't have any information about bonds.
Okay.
Also, day is coming up in 5 minutes if we're discussing bond.
Okay. So tell me, what's going on?
Mr. Pena, I don't want to get too far into attorney-client
Sure, of
communication.
course.
He would like to ask for a new appointed lawyer.
Why?
Well, me and her had a conversation. Like, there's nothing against her, but we just had a conversation, and I didn't think that
She's fighting for you?
you could
She's
say-
one of the biggest junkyard dogs that we have here. There's no one that fights more than she does.
No,
She's better than most attorneys I even see here. I'm telling you, she's amazing.
no, I believe you. You could be saying the truth, but
I am saying the truth.
no. I know you are. I believe me.
Okay, this is a moment that reveals something really important about how the court system works. The defendant wants a new court-appointed lawyer because he doesn't think his current attorney is fighting hard enough for him. And the judge's response? She's one of the biggest junkyard dogs that we have here. There's no one that fights more than she does. She's better than most attorneys I even see here. That is high praise coming from a judge who sees lawyers day in and day out. Here's the reality that many defendants don't understand. Court-appointed lawyers aren't lesser attorneys. Many of them are exceptional advocates who handle the toughest cases with limited resources. The judge denied the request for a new lawyer, and here's why that matters. Changing attorneys typically delays cases, requires new lawyers to get up to speed, and often doesn't change the underlying facts. Sometimes defendants think a different lawyer will get them a different result, but as the judge pointed out, it doesn't matter if you have Jesus representing you. When you have a pattern of criminal behavior, the evidence speaks for itself. The defendant even admits he actually knows this lawyer from his prior gun cases, and those cases were handled well. Sometimes the problem isn't your representation. It's the choices that brought you to court in the first place.
And just off the fact, the cases, the other price case that you did bring up, I haven't had. It was a year and a half already, and it's only been for for protection. Like my other cases, I'm not no bad dude that robbery or they're all gun charges, and that's just on the behalf of the landscaping business that I got. That every time when I'm in the backyard or so, somehow they're always trying to steal the back of the trailer. That's the only reason, and the only cases that I got. I don't got no evading arrest, no like robbery or what, however you.
I don't know, but we have another prosecutor that's coming up to speak about this as well. I'm not going to give you another lawyer. This is a lawyer that we've given you. We only have a couple lawyers who do these types of cases regardless.
Okay.
So,
The only thing I was gonna, I'm sorry, I didn't mean to cut you.
Okay.
The only one I was gonna ask you was I was trying to get the lawyer that fought for the two gun charges. I don't know, Mr. Some with, I just forgot. I think he's an Italian dude.
Those cases you had.
They have the same guy. And I really thought it was him right here.
Oh, it is Greg.
I know why you look familiar. Yeah.
Yeah, Greg, you represented Mr. Pena on both of his prior cases.
Oh, yeah.
Yeah.
Oh, man.
That's why when I looked at it, I was like,
So, look, the only way you can have Greg is you can hire him. Otherwise, you got Anna. Okay?
oh, yeah, he's getting, oh, now he charges
Hire him.
that. Look at
I always charge. I don't know what you're thinking.
All right, we're going to put you back because we're waiting on another lawyer to come up here.
Let me talk morning or good afternoon, whatever it is.
What happened, Dave? Are you upset
Too
with
late, Judge. I didn't, I missed that you set a $5,000 bond on Anna's other client.
Look, I didn't see very much violent history. I saw that this is yes, but it's been 5 years since he's gotten in trouble. Do you have something to add? I'm all ears.
Well, I let Amy prepare it, so I'm gonna just let sleeping dogs lie. I just, yeah.
I didn't see much violent history. I saw DWI, I saw evading, but those back from 15 and 16. You know,
It was I mean, it's already done, so it's, at this point,
do you have something that's truly aggravating that would give cause for concern?
well,
I know the facts of this case, right?
and, well, the argument I would have leaned more towards is not the, necessarily the physical danger, but it's the flight risk of it and the aggravating circumstances of what he's wanted for, but,
Hey,
yeah.
if you run, can't run forever. We'll get you eventually, number one. And the worst part about the case that I saw, gets out of the car, puts her in a full Nelson. I didn't have anything more than that, you know, there was no blood, there's no, you know, the history was, you know.
It was more flight risk and the fact that one of the conditions, well, if we're talking about the warrant.
It was a 2B.
It was a 2B and one of the conditions they asked was no contact, was my understanding. The complainant's in the gallery.
But she came on her own accord.
No, I understand, but it's the same as domestics here is, I understand that they're obviously willing complainants or recanting
Alden
complainants, but in
Garcia?
the domestic part of things.
But if it's a 2B, he hasn't been ordered by the court. So he doesn't know,
No, I know. And I
he's
was
not on notice.
No, my argument wasn't he wasn't violating any bond conditions. That's not what I'm saying. What I am saying is if one of the concerns, right, is that they would go out of their way to put it in the teletype and to the warrant to us, that it is a concern that they have contact, is one of the things that would facilitate and ensure the no contact instead of him being free and odds cash in my pocket says,
Yes.
right, but cash in my pocket
And
says,
Anna's gonna let him know, so that he now knows.
but anyway, all that said is it's already done, so I'll move to the next.
Okay. Mr. Pena, thank you for smoothing that over. He would like to ask the court for a fugitive bond. I told him it was a long shot, but I was not going to presume to speak for the court.
We need to bring someone out. Lee, Pena, please.
You and Ricardo are getting some wins.
Hey, Vic, do you want to go through the list? Or no? You're not ready?
Well, you weren't here yesterday.
That's true. That's true. I'm also wildly sleep deprived. The intake wasn't too bad last night. It was a steady flow. It wasn't too bad. It's a little tired. Yeah. It's good fun.
Three on one, two, yes. Two sisters. Brad.
Did you want to go over to?
Yeah.
Page 5, Davis. Seth or Raymond failed to appear first time.
Right.
2501.
Right, page 7, Estrada. You took a man, how much is that?
5001 on the DWI.
Ready for the next one?
No, give me 1 second. Let me finish the bail order.
El precio de distribución. Pero no es
Okay, who's next?
Next, is age 13, Jenkins. That already felt to be a concern.
2501. Okay. I'm not happy with you, and the thing is that, Mr. Pena. Since you've been an adult, you've picked up 1 to 2 cases every year. It would scare me to let you out because I don't know what you're going to do. The last thing I want is for me to let you out and you leave just a path of destruction like the Tasmanian devil. You now have a DWI here. You're wanted for 3 charges in, where was it again?
Indiana.
In Indiana, you're hopscotching states with criminality. And you're only 23.
This is the moment where you can feel the weight of the judge's decision. Let me break down what he just said. Since you've been an adult, you've picked up 1 to 2 cases every year. This defendant is only 23 years old, meaning he's been an adult for about 5 years, and he's already accumulated multiple criminal cases in multiple states. The judge's imagery is powerful. It would scare me to let you out because I don't know what you're going to do. The last thing I want is for me to let you out and you leave a path of destruction like the Tasmanian devil. That's not just colorful language. That's a judge expressing genuine concern about public safety. And look at what this defendant is facing. An open DWI in Harris County. A warrant out of Indiana for corrupt business influence, forgery, fraud, and identity deception. Multiple prior gun cases. Failed to appear on at least 1 case. The judge used the phrase hopscotching states with criminality, meaning this defendant isn't just committing crimes locally. He's creating problems across state lines. And here's the key factor in bond decisions. Flight risk. When someone is wanted in another state, has a history of not showing up to court, and keeps accumulating new charges, judges become very reluctant to grant bond. The court's primary concern is ensuring people come back, and this defendant's track record doesn't inspire confidence.
I don't feel comfortable giving you a bond because I don't think that you will comply with the court orders. Sure, just don't talk about the cases.
Oh, no, I'm not talking about, sir, believe me, I understand where you come from, because it's probably not the first time you see it, but, my cases are not, never hurting nobody. I'm not a menace to society.
What else was it?
Your Honor, it's fraud, identity deception, forgery, corrupt business influence,
But nothing with, no disrespect to you, I promise, no disrespect, but nothing that has, that I hurt somebody or make somebody do that they didn't want to, or like.
Have an open DWI.
For doing a favor.
Stop.
Oh, sorry.
Yeah, don't.
Yeah, sorry.
If you go out there and you kill a family of 4, do you think, well, he was going to try to help someone? Do you think they care?
I was asking her, I was like, at least, because my mom, it's the Indiana case is like 14 hours if I'm not mistaken, and well, my mama don't got enough money to be going back and forth. So that's why I was asking her. I'm like, if he, I'll do anything that however he feels comfortable, like however you want. I was like, can he at least put me a monitor to drive with my mom over there at least one time, because I haven't seen my mama, and I'm not gonna be able to see my mama if I end up going all the way to Indiana, because she don't got enough fun to even go over there like every week. And sir, like, believe me, I'm not no bad person.
Concern is whether you get to see your mom. You know what I mean?
Understandable. No, that's understandable.
Yeah.
No disrespect.
My only concern is that you get to Indiana to
Yes, sir.
get the charges.
Yes, sir.
Now, the problem is that you refused extradition. So you aren't even earning credit now toward, because when someone waives extradition, we give that other state
Yes, sir.
14 days to come get you.
Yes, sir.
And if they don't come get you,
Yes, sir.
then Harris County releases you.
Yes, sir.
Right? The warrant don't go away.
Yes, sir.
That warrant will also remain.
Yes, sir.
But at this point, I just don't feel comfortable giving you a bond, Mr. Pena. You know, you're just too young. You keep picking up criminal cases and it scares me.
Well, can we come to like an understanding? Like, let's just say I do suppose, like, however you think that I'm finna do, I'm really eventually I'm gonna come back, and I'll do more time than I have to. Bro. I'm giving you my word that
I don't feel comfortable,
You
Mr.
feel
Pena.
that's acceptable. That's acceptable.
Because the
Judge.
problem is that with the cases that you had with us, I also had to revoke your bond on those cases when you were just here with us.
Yeah,
You know,
no.
you failed to appear on one of your cases, and that's just here in Harris County. On one of the gun cases, you took off and we had to issue a warrant for your arrest.
No.
No.
Okay.
And Judge,
The bond's at 1,001.
just if I may, I believe both of the gun cases were ultimately dismissed.
One was dismissed, the other one.
One's not.
Oh, okay. I apologize for my misunderstanding. I thought they both.
So he probably pled to one where they dismissed the other one.
Okay.
He was on bond and he picked up a new case. That's what it was.
No, it was a
No.
year after. But actually, in part of housekeeping, if you wanted to go forward with the 2-year rule, or if you didn't want to.
Okay. So his DWI is in court 15. I don't know if they're going to send that back because of the.
We killed the 2-year rule.
Oh,
Didn't know that. Okay.
Yeah, it was like, when was it, like a month ago or so?
Oh.
Yeah, so there's no more.
okay.
It's still like all fresh and new. We have to update the court rules, but as far as
Okay.
the 2-year rules now, gone.
Okay.
Okay.
Yeah, because the problem is that judges would get to, you'd end up seeing the same people over and over, and then is it really fair because you end up, right? You
That makes
start developing a relationship and you start treating them differently as you would.
Right.
So that's why. So now you refused. I'm not going to give you a bond. So you have two options. You can, if you want to continue to refuse, they will go get a governor's warrant from Indiana to forcing Indiana to come get you, but that will take 90 days. If you want to waive now, you can waive now, and that'll give them 14 days to come get you. I'll let you talk with Anna to make the decision to let you know what you want to do.
And he did sign the waiver. Just,
Oh, okay, all right.
So.
Got it.
Time started yesterday.
I just started
Right now,
So they'll have.
the time that you waive,
They'll have-
which is right now.
Yeah, I had signed the paper yesterday, if I'm not mistaken. I sure did. Cause she said it starts at 12, that day that I signed my paper.
Okay.
It's up to them whether they want to.
Oh, I'm sorry. Yeah, at
No, it
first,
shows a refusal.
at first it was I had signed for the 90 days, and she said tomorrow you got an option to tell your lawyer that you could change your mind tomorrow.
Okay.
And then I was like, when did the day start? She's like, tonight at 12.
It's a refusal.
And that is a wrap on one of the most legally complex and emotionally intense courtroom sessions we've covered. Let's break down the major cases. First, the defendant who made 21 phone calls in a single day to someone he was court-ordered not to contact. Bond instantly revoked. New bond set at $50,001. And a warning that the next violation means a hearing for no bond at all. When judges say no contact, they mean no contact. Second, the Dick's Sporting Goods case where someone was accused of covering for a shoplifter and got physical with an off-duty officer. In a rare outcome, the judge found a no probable cause and dismissed the case, but still offered wisdom. When you get into a pissing match with people who have the power of arrest, who's going to win? Every single time. Third, Destiny Drake Osby, who was on bond for DWI and picked up an aggravated assault charge after beating her ex with a 12 to 16-inch metal bracket, causing lacerations to both eyes, all over a phone. Bond revoked. New bond set at $51,000. Fourth, Mr. Jorge Pena. The 23-year-old wanted in Indiana for fraud, forgery, and identity deception, with a pattern of 1 to 2 criminal cases every year since becoming an adult. The judge called him a Tasmanian devil, leaving a path of destruction and refused to grant a fugitive bond. His options? Wait 90 days for a governor's warrant, or waive extradition, and give Indiana 14 days to come get him. The through line in all of these cases? Patterns matter. Judges aren't just looking at one incident. They're looking at your entire history, your compliance with court orders, and your likelihood of showing up and staying out of trouble. When you establish a pattern of violations, flight risk, or escalating behavior, the court's patience runs out fast. If this breakdown helped you understand how bond decisions, probable cause, and extradition really work, smash that like button. Drop your thoughts in the comments. Was a judge right to deny the fugitive bond? Should the Dick's Sporting Goods case have been dismissed? What do you think about the 21 call protective order violation? Don't forget to subscribe and hit that notification bell so you never miss another jaw-dropping courtroom breakdown. Share this video with anyone who needs to understand the real consequences of violating court orders. Until next time, stay safe, make smart choices, and remember, when the court gives you conditions, they're not suggestions. They're the difference between freedom and sitting in a cell waiting for your case to resolve. Peace.